Well, hopefully, in that scenario, the parties had counsel draft up organizational documents, and that could take the form of a partnership agreement, whether that's a limited or a general partnership agreement, a corporation, an LLC, those types of business organizations, because certainly, you have scenarios where people will be sole practitioners or be sole proprietors of businesses, and for one reason or another, they won't feel the need to form those business entities, and then they have tax consequences that are negative that are involved with that, and then also too they have exposure to liability. So hopefully the quote-unquote partners have had the good sense to hire an attorney to draw up those documents and have a formal business organization that's been formed. Now, having said that, assuming that that's been done, there are levels as to how involved those documents are. And you can go ahead and file articles of incorporation or articles of organization if it's an LLC with the state of Florida, and then kind of forget about it until your next year dues roll around and you have to have your annual meeting, or you're supposed to have your annual meeting. But typically that is not the best way to handle organizational documents when it comes to creation of businesses. And so with the corporation, not only would you have the articles of incorporation, but you would have bylaws, or you would have agreements in regard to shares of stock that would be issued to the owners, and how much and what would happen if there's a disagreement, or if there's a dissolution of the corporation, whether that be voluntary or involuntary. The same thing with LLC. You would have the articles of organization, or like the articles of incorporation, but then you also too have a guide that basically spells out what the responsibilities and obligations are for each party, and those can be fairly simple or they can be very, very complex, depending on the nature of the business. And those should really state what happens in a case where there are disagreements. Is there a buyout clause? Is there a right of first refusal for selling stock or selling interest, membership interest in the LLC? So those kind of things should have been handled from the beginning, so that if there arises a problem, there's already at least some kind of guide that the parties can use, and that the attorneys for the parties can use to try and settle disagreements that come up. And they may not be something that's a make or break as far as the business organization actually dissolving, or the quote-unquote partners splitting up. So there may be ways to resolve disagreements through those documents that were created, hopefully in the beginning. And once those documents are created, they will help to guide the owners, or the people that hold the membership interest or the shares of stock. And even if it's done on a partnership basis, there should be a partnership agreement that kind of spells out what the interest would be and what happens if there are those disagreements. Now, those all can't be fixed by by negotiation or by agreement, and so sometimes that comes to litigation, and then obviously each side would need to have their own independent counsel and try and work through the court system to get a resolution in regard to that. But if they've done it right from the first place, it'll avoid a lot of expense, time, money, heartache, you name it. So the more prepared you are in the beginning, the better off you are. Now, I understand that small businesses, are usually started on a shoestring budget. But having said that, it's the old saying about being penny wise and pound foolish. So, you save a couple of grand by not going through this process with the attorney and getting everything set up. And then pretty soon you have a disagreement and you're in court and you may be into the tens or hundreds of thousands of dollars or more if the business becomes successful very quickly. So the best way to do that is to handle all that upfront as best you can.